SJC-12315, Ibner Casseus and another, v. Eastern Bus Company, Inc., and another.
Excuse me, Mr. DG. You haven't spoken yet, and we're already choked up from your. You may proceed.
Chief Justice Gantz, Associate Justices, Damian DiGiovanni for Defendants, Appellants, Eastern Bus Company, and Charles Winitzer, and may it please the Court. The Massachusetts overtime law generally provides that non-exempt employees in Massachusetts are entitled to 1.5 times their regular rate of pay for all hours worked over 40 in a given work week. However, the law similarly provides 20 separate exemptions to that general requirement, which this Court can find on pages 8 through 10 of the addendum to our brief. Relevant to this case, subsection 11 states in clear, plain, and unambiguous terms that entitlement to overtime compensation shall not be applicable to any employee employed by an employer licensed and regulated pursuant to Chapter 159A. The Superior Court denied defendants' motion for summary judgment and granted plaintiffs' motion for partial summary judgment, despite finding that all of the plaintiffs in this case meet the statutorily description of an exempt employee, and that they're all.
Could a company go out and just have an aspect of their business and involve a charter license and then not have to pay any of its employees overtime?
The way the statute's written, yes. But I would say this, that sort of significantly minimizes the role that the Department of Public Utilities plays in granting these types of licenses. As far back as 1966, this court in the Goodwin case, discussed sort of the significant role that the Department of Public Utilities plays in granting those licenses. So for that example, I would imagine that a company that wanted to skirt the overtime law that simply tried to get a license under 159A probably wouldn't be granted one. Now, the focus in this case has been on Section 11A, but it's the entirety of 159A that the exemption sort of applies to here. So to answer your question, the plain language of the statute would sort of result in that, as you just described. And I'll say this.
But there's also plain language in the statute that says charter service shall not include the transportation of school children to and from the school pursuant to a written contract with the municipality. So don't we have to read that along with the other language you've got?
Well, I would point out that that's an exception to 159A. The focus of this court and what should have been in the Superior Court is that the exemption language under 151, Section 1A, if you are licensed and regulated pursuant to Chapter 159A, your employees are exempt from overtime from.
That's because you're engaged in a charter service, right?
I'm sorry?
That's because you're engaged in a charter service, right?
That's one of the reasons. So I'd like to point out that that has been one of the major focuses of this case, starting at the Rule 12 motion, that Eastern Bus does have a Chapter 159A, subsection 11A charter license, but it's also regulated under 159A in other aspects. If you look at Section 9, all of its employees need to be regulated under 159A. They have to have a certificate to drive school buses. Eastern Bus is required to register all of its vehicles under 159A with the Department of Public Utilities.
The proportions don't bother you? There's no issue about how many hours you spend on school routes versus charter service?
I would point out that charter service is a significant part of Eastern Bus's business, and
But you're saying it's categorical, though, right?
I agree. I don't think that that's relevant to the case, but I would say that it's not an unfair proportion of the amount of work that's done that the plaintiffs don't dispute is regulated under 159A.
So how categorical is it? That is, Eastern Bus, I expect, have people who work as secretaries and accountants and janitors. Are they exempt from this too?
So I would answer that in two ways, Chief Justice. First, the Department of Labor standards, which employers are expected to go to for sort of counsel and guidance on these types of questions, specifically address that point under subsection 12 with the hotel exemption. And in interpreting that broad language of the exemption, it said we do agree that this will exempt a broad sort of spectrum of employees. However, A lot of those employees are covered under federal law as well, and that would be the case here. The secretaries, the janitors, those folks would be protected under the FLSA, which wasn't a claim in this case, Your Honor. So they would be exempt under subsection 11. However, there are other protections, especially under federal law, that would provide them overtime, which the drivers in this case, the class members, would not similarly sort of have that because they're exempt under the Motor Carrier Act as well.
But under the, but you're saying that as far as state law is concerned, they'd be exempt?
Correct. And I would point to the other cases that we cited in our brief, that other courts, both state and federal Massachusetts courts, in interpreting other similar exemptions under the overtime law, they've all interpreted it the same way, in the sense that if you work in a particular location, a hotel, a nonprofit school, all of the employees are exempt. And if you look, just as an example, the Cambridge Health case, that was a registered nurse, a secretary, and a patient access representative. So there was no analysis of the specific work that was actually performed. If you meet this enterprise exemption, those employees are exempt under Massachusetts law.
Well, you just mentioned the other exemptions, and the other exemptions use the word in, and 11 uses the word by, I believe. Doesn't that annoy to your detriment?
I don't think it does, and I'll tell you why. Those types of exemptions can be tethered to a physical location. So if you work in a hotel, if you work in a nonprofit school, that makes sense. It wouldn't have been rational for the legislature to create an exemption for transportation companies tethered to a physical location. By nature, their work is not in a physical location. You are driving a bus, you're at the depot, you're moving from point A to point B. So I think that the in versus by, the use of that language doesn't sort of take away from our analysis here, because by nature, transportation companies, you're not performing your work in a physical location. So being employed by a company that's licensed and regulated, I think that's why they use that specific exemption.
As I understand your argument, it's just that it's just plain language, the full stop. You don't go behind it, you don't look at any of the statute, you don't try to read it in connection with anything else, full stop.
Correct. And as I was sort of at the outset of the argument, what I was going to say, and this court has always sort of followed that way of statutory interpretation, in the sense that if the language is plain and unambiguous, it is conclusive to legislative intent.
How about if it achieves an absurd result?
We don't believe that this is an absurd result in this case.
Don't, but I mean, isn't that an exception to that full stop? If that's what the language says, that's what the language means?
I would agree that if it does sort of result in an absurd result, Your Honor, but the way that other courts in Massachusetts and the way that the Department of Labor Standards have all interpreted similar exemptions, they haven't found that to be an absurd result.
But here you have an exemption to the exemption of school routes, right?
We have an exception
Exception to
under
exemption,
159A. I do think it's important to separate those two things out. And I'd like to point out on that point that the exception is much more narrow than plaintiffs point out here, and I'll tell you why. The to and from, transportation to and from for school children, that is limited only to in the morning and afternoon back and forth.
Well, where does it say that?
Where does it say?
That it's limited to that?
Well, presumably it's allowing the municipality some regulatory power over the transportation. It wouldn't make any sort of rational sense for the legislature to say, and by the way, I'm referring to field trips and athletic events as the sort of disputed charter work that there's been a discussion about. It wouldn't make any rational sense for the legislature to allow regulatory authority for the city of Newton for transportation that occurs outside of the city of Newton. So just by nature, a field trip or a basketball game, a company's taking a team from Newton to Wayland, it wouldn't make any sense that the legislature would say, okay, city of Newton, you can regulate transportation outside of the city of Newton. So while the statute doesn't necessarily specifically say to and from home, the way the statute's been narrowed, as we point out in our reply brief over the years, it makes rational sense that the state wanted more regulatory authority over that transportation.
I don't get that argument. I mean, why wouldn't we interpret to and from to include extracurricular sporting events or trips to the museum? Why isn't that? Why wouldn't that be included? I mean, it goes to school and from school, right?
Right, and as I just mentioned, I think
it goes from school to, and but it's basically the same concept. It doesn't say from home to school.
And I would point out that the work itself, the private charter work, so if, you know, you wanted to take a group to a wedding, that would be a private charter, which the plaintiffs do.
I get that. I understand why that's different, but I get it if they're renting out their buses to do weddings on the weekends.
Right.
But I don't get why to and from school doesn't include extracurricular.
Well, the work's exactly the same. So
No, it's not. It's related to the school contract.
So the school contract, as we mentioned, they guarantee 180 days worth of school days. So that the companies contract with these schools to provide that, and it's a guaranteed payment. Eastern Bus is going to perform 180 days worth of work. It's not guaranteed for the field trips and the athletics. Well, I would view it more as a preferred vendor contract in the sense that a lot of these contracts say we're not bound to use Eastern Bus, and if they don't have any sort of charter work, they don't use Eastern Bus. I guess my point on your last point is the sense that views sort of the city of Newton as saying we need a charter company to take our basketball team from point A to point B. The work's the same. So to sort of lump that in, and I would also point out that the prevailing wage rate in Massachusetts has different rates for the school charters, as we would say, versus the to and from school. I think that's significant as well, because if it was the same work, the rates would be the same.
But if the exception to the exemption is meant to deal with basically school bus contracts, I just don't see why it wouldn't include all the work for the school, because it's all part of the same, pot.
Sure, and again, I'm going to point out again, just to clear the record, that it's not an exception to the exemption. There is an exception under 159A. The exemption is separate, and if you're licensed and regulated as an employer, you're exempt from the requirements of the overtime law. But the exception part of it, it's not, and again, I want to point this out, the exception isn't if you're licensed and regulated under 159A, Section 11A. It's if you're licensed and regulated under Chapter 159A. And as I pointed out, there are various other requirements under 159A that Eastern Bus is always regulated. Their employees are always regulated. Their vehicles need to be licensed and regulated with the DPU. As I said, so there is that exception, but it's not limited to 11A. It's limited.
Let me ask you this question then. Does a school bus company have to have a charter license to transport students to and from extracurricular activities?
Yes, I would, and you could look to the Boston contract as an example. While I understand it's not, it's one, but it's the largest municipality in the state. And they do, on all of their bids, as we cite in the record, you need to be, the company needs to be licensed and regulated to perform charter work, and the drivers need to be licensed and regulated to perform charter work. And Eastern Bus is one of Boston's preferred vendors for extracurricular activities. They do not perform the to and from school. So I think that, yes, to perform the extracurricular, and again, the reason why is by nature you're transporting groups of people from one municipality to another. That's intercity versus intracity. So to the extent that there was some exception to their 159A subsection 11A, it would be limited to intra-city work, because it just wouldn't make any rational sense to say that one municipality can regulate transportation in another one. And by nature, that's what that work is.
So your view is that the sentence in 159A, Section 11A, which says this section shall not be construed so as to prohibit the use of school buses under contract to a school system in transporting pupils to and from ... school-sponsored extracurricular activities means only within the same town?
And the focus of that last sentence is the particular vehicle that can be used. It's not the actual work. So I think that's an important distinction. I know it's sort of been lumped into this argument, but that talks about whether or not certain vehicles contracted with certain towns are allowed to be used in that type of setting, not whether it's charter work or to and from school. So I would say it's sort of a red herring in this case, Your Honor, in the sense that I don't think that it's relevant. And sort of moving to our second point here, if this court decides that it does... Sorry.
Before you leave the first point, does DPU, as part of the licensing process, place any restrictions in terms of the payment of employees or bus drivers?
There is a maximum hours requirement similar to the Motor Carrier Act exemption, and that's in the regulations. We cite in our brief, but it's 220 CMR 150.
So it means that you can't have them work too many hours on a certain day unless they fall asleep at the wheel. But is there anything that protects them from not being paid for overtime or not being paid for time above and beyond the 8 hours?
Not under the DPU regulations, no.
So DPU basically doesn't do anything to protect bus drivers with regard to payment, except to keep them from falling asleep at the wheel.
Well, the safety part of it, you're right. But I guess to that point, I would direct Your Honor's attention to the Motor Carrier Act analysis in the sense that the Federal Motor Carrier Act, which Judge Gordon at Rule 12 suggested should be the analysis applied by courts when dealing with subsection 11 and analyzing cases thereof. The Motor Carrier Act or the Secretary of Transportation on the federal level doesn't either. They have the authority to regulate qualifications of drivers as the DPU does at the state level, and they have the authority to regulate maximum hours of work as the DPU does on the state level. But as we cited in our brief, every single court of appeals in the country, as well as the United States Supreme Court, has analyzed the Motor Carrier Act exemption in the same way we're asking this court to do if it doesn't feel that the plain and unambiguous language should sort of.
But you
hold the
understand that what the plaintiffs are saying is there's a subsection already, subsection 8 it might be, that correlates to that act, and that we should look therefore to other provisions of FISLA and look at those, like aircraft as well, or rail, to really understand the application of BS Standards Labor.
Sure, and I'll respond to that in two ways. First, I think that argument sort of falls on top of itself because the plaintiffs want to use the Railway Labor Act as the guiding light, but that subsection 8 under the Massachusetts law similarly sort of uses the Railway Labor Act. So it's both the Motor Carrier Act and the Railway Labor Act. So they're saying you can't use the Motor Carrier Act exemption as a guide because there already is an exemption in Massachusetts law. Use the Railway Labor Act, despite the fact that there's also a Railway Labor Act exemption under Massachusetts law as well. So if you sort of take that general principle then that the court needs to decide what's the best analogy to use, in our view it's the Motor Carrier Act because both both exemptions deal with ground transportation, specifically, not specifically, but bus transportation as well. Not to mention Eastern Bus is also regulated under the Motor Carrier Act exemption because it performs interstate work. So I think that argument, the fact that there's also a Railway Labor Act exemption under Massachusetts law, it sort of collapses on itself because at that point then the court needs to decide which is the more apt analogy. And in our view, it's the Motor Carrier Act. And also I'd point out that the Rule 12 decision that the plaintiffs are vigorously defend, as well as the Judge Curran on the motion for summary judgment, that Judge Gordon said you should use the Motor Carrier Act exemption as the analogy. Now, it didn't get dismissed at that level because in the four corners of the complaint, there was absolutely no regulated work alleged, but I think that's important to keep in mind as well.
I'd like to hear your fallback argument, because I'm curious what that is. I'd like to better understand that, because I'm bothered by the fact that some of the bus work seems to not fall within the school bus contract. And I'm trying to understand how you treat that.
Sure. So I guess the analogy would be if you're treating subsection 11 of the Massachusetts overtime law in the same lens as the Motor Carrier Act exemption. The courts of appeal, all federal courts view the Motor Carrier Act exemption as if you do a modicum of regulated work, the entire class of employees fall under the exemption. We cited the Reach case, and I apologize, a lot of the cases sound alike in this case, where they performed 1.3% of regulated work. So the analogy would be interstate in the Motor Carrier Act exemption is the same as private charters.
I'm posing, I think, a different question
Sure.
to you. Assume you lose. I'm not saying you will, but assume you lose your global argument. And what you're relying on, and all you've got left is the charter stuff, the pure charter stuff, why that should be excluded. Because what Justice Gordon does is he denies summary judgment for you, but he doesn't grant summary judgment to them. Then Justice Curran takes it one step further, and I get lost when he does the next part of this. So,
To be perfectly frank, we got a little lost as well on that because he didn't cite any cases or any support under Massachusetts law, and we would submit that there was really no basis. He agreed with Judge Gordon in terms of not dismissing the case or not being listed as blankets, but he didn't rely on Judge Gordon's analysis.
but here's my
Sure.
point. And I'm not saying this is correct, but say Justice Gordon got it right, that your categorical exclusion doesn't work. But there's a real issue about this pure charter stuff. When you go perform weddings on the weekend, I can't calculate, if that's wrong, if Justice Curran took it one step too far, what do we do? Because say 20% of this is for this kind of weddings, it has nothing to do with school.
So, excuse me, I guess our response would be this. If the court's going to apply a different type of interpretation, if it needs to look to the federal law for guidance, the Motor Carrier Act is the most apt analogy. And the way that courts have applied the Motor Carrier Act exemption is, and by the way, just so it's clear, intra-state work isn't regulated under the Motor Carrier Act. Interstate is. So if you want to use the interstate analogy as the private charter work, just about every single court of appeals on the federal level, including the United States Supreme Court, said if you do any type of work, or if you can reasonably be expected to do exempt work, you exempt the entire class of employees.
So even though,
So
so if only 20% of the bus drivers' work is for weddings on the weekends, then all of their work is exempt from the federal law, then all of their work should be exempt under the overtime stuff?
So all of the drivers for Eastern Bus need to be licensed to perform charter work, and they are expected to be able to do that, and they do that as a regular part of their job.
Right.
To answer your question, the plain language of the statute dictates that all of the employees of Eastern Bus should be exempt from the overtime law. If they want to take it a step further where we need to look at an analogy under the federal law, then yes, to answer your question.
So even if we disagree with your interpretation that we've got to exclude everything, and we conclude all of the charter stuff is not covered by the exemption, we would still not apply overtime law to any of your employees because 20% of the time they do weddings?
It could be reasonably expected to do that, Your Honor, based on the Motor Carrier Act exemption. And I just, sorry, go ahead.
No, I just wanted to make sure I understood your argument.
And that's based on sort of, I would say, overwhelming precedent from the federal courts. That's how they've sort of analyzed that similar exemption under federal law. And again, that's sort of what was proposed to us after the Rule 12, that should be the federal. If this court doesn't believe that the plain and unambiguous language holds the day, which we would submit that it does, the Motor Carrier Act analysis should be applied here. And ironically, had Judge Gordon been the judge presiding over the Rule 56 motion, this case would have been likely dismissed at that stage as well, based on his own, what he perceives should be the proper analysis here under the analogous Motor Carrier Act exemption.
Okay, thank you.
Good morning, Your Honors. Ian Russell for the plaintiffs. Defendants argue that the exemption at issue here, Section 1A, Part 11, the Massachusetts Common Carrier exemption, must be applied in a blanket manner to all of their employees.
Isn't that what the statute calls for?
No. In order to interpret the statute, it first makes sense to look at the statute that it is based upon, that it is modeled upon. And this court has recognized on a number of occasions that the Massachusetts overtime law is modeled on the Fair Labor Standards Act, the FLSA.
Why do we do that before we look at the plain language?
In this case,
Is that an interpretive device if we don't know what the plain language means?
I would say that it is,
Statutory history or why it was enacted or anything, that comes if we don't know what the words mean, right?
well, I would say that it is different in a case where one statute is modeled after another.
Have you,
Beyond that,
well, never mind.
oh, I'm sorry. Beyond that, I would say that the language of the exemption itself does require an analysis of whether the work that is being performed is regulated. In fact, it requires an analysis of whether the portions of the business of the employer are regulated. The exemption refers to an employee employed by an employer licensed and regulated pursuant to Chapter 159A. And as has been discussed today, with this particular defendant, a large portion of their work is not licensed or regulated under Chapter 159A. Now, the defendants have indicated that somehow Section 11A of Chapter 159A does not include an exemption from coverage under that law, but that is exactly what it is. It states clearly that the regulations and the statutory framework does not apply to work that is performed under a contract with a school authority, transporting students to and from school. And in fact, in some of the legislative history that was provided by defendants to show some changes in the language, the legislative history states explicitly that they are clarifying the exemption to the law. So it is in Section 11A does include an exemption from all licensing and regulation under Chapter 159A. So when you look at the overtime exemption, one has to look at whether the employer is licensed and regulated pursuant to Chapter 159A. And in this case, where the vast majority of their work is not regulated and is not licensed pursuant to Chapter 159A, that means that the language of the exemption is requiring some look at the type of work that is being performed. Given that, it then does make sense to look at the similarly drafted exemptions under the Fair Labor Standards Act. And in our briefing, we have brought to the court's attention 3 particular exemptions that I think are illuminating. One is Section 213B2, which relates to any employee of an employer engaged in the operation of a rail carrier subject to Part A of Subtitle 4 of Title 49. The other is Section 213B3, which refers to any employee of a carrier by air subject to the provisions of the Railway Labor Act. And the other is Section 213B17, which relates to any driver employed by an employer engaged in the business of operating taxi cabs. These 3 exemptions are illuminating because they have consistently been interpreted not to apply in a blanket manner. Each of these exemptions applies either to an employee of an employer subject to particular regulations related to transportation, or by an employer engaged in a particular business.
But why wouldn't we look at the Common Carrier Act? If we're looking in that direction, why wouldn't we look at the Common Carrier Act instead of finding out what babysitters do and what
Well, again,
rail and
our brief is not based on the babysitter exemption or the other exemptions. It is focused on these that are related to transportation. And the reason that we would argue that you should not look to the Motor Carrier Act exemption is because it is drafted in a very different manner. That exemption relates to any employee with respect to whom the Secretary of Transportation has power to establish qualifications and maximum hours of service pursuant to the provisions of Section 31502 of Title 49. That is drafted entirely differently than the exemption that we are talking about in this case. And as you mentioned earlier,
Under Section 11A?
It's drafted differently than the 1A Part 11 exemption.
Sorry?
I'm saying that the Motor Carrier Act exemption in the FLSA, which relates to any employee with respect to whom the Secretary of Transportation has power to establish qualifications, is drafted very differently than the exemption under the Massachusetts overtime law, Section 1A11, which relates to an employee employed by an employer licensed and regulated pursuant to Chapter 159A. So there is a large difference in the way that they are drafted. And
So
the fact,
I'm going to take a variation on Justice Kafker's question. Let's assume you are right that regulated, that non-charter service should be in some fashion treated differently under the overtime law. How would then the calculation of overtime be done?
well, our first argument is that the exemption should not apply to these employees.
And even though about 40% of their time is charter work?
Well,
Or
we don't
between-
agree that 40% of
Okay,
the
so let's say
time
it's
is-
30, 20%. I mean, where do we draw the line? What percentage is too little?
Oh, we would argue that where a substantial portion And we would refer to the federal regulations, which have interpreted a substantial portion to be 20% or more.
We're supposed to incorporate into a state statute the FSLA regulations of a federal statute and say that 80% is to be what the legislature intended?
It provides guidance as to how these similarly drafted exemptions were to be interpreted. They were interpreted that way at the time these regulations existed and had been promulgated at the time that the Massachusetts overtime statute was enacted in 1960. We do offer, alternatively, if the court were to not refer to those or to not want to look at what is a substantial portion, it is possible to separate out the work that is regulated from the work that is not regulated.
So how would that work in practice? I'm a bus driver who spent 30 hours doing to and from school and another 30 hours doing charter. Put aside the issue of whether the trip to the Newton football game is going to be charter or not, but just charter.
Well,
It's 30 hours of school work, 30 hours of charter work. So what overtime do I get? Do I get none because it's only 30 hours of charter work, or do I get 20 hours because I work 60?
Well, again, if we're setting aside our initial argument, then I would have the court look to whether the charters, and I use the term charters broadly because Eastern Bus refers to all of this work as charters. At that point, you would have to look at whether the charter work was performed for a school under a contract.
Okay, but just, let's assume,
Put
that aside, it's 30 and 30.
For a particular employee, if under our alternative argument, under the particular employee situation you have described, if they have 30 hours that are school and then 20 hours that are related only to charters that have nothing to do with a school, then under the second alternative, if you're just separating the hours, that employee would not get any overtime. However, if you had a slightly different situation in which an employee had performed 30 hours of what Eastern Bus admits is schoolwork, and then 20 hours of work providing, or 15 hours of work related to charters for a school, putting them with just looking at those hours, 5 hours over. And then if they had 10 more hours performed for a private entity, if you were looking at it in that way, then the individual would be owed 5 hours of overtime.
So under this second alternative, which I know is not your preference, you'd prefer us to adopt the FLSA 80%, we would count for overtime purposes only the schoolwork.
Yes, and you could do that without referring to the FLSA because, in fact, Eastern Bus is only regulated under Chapter 159A for those portions of the hours that are not related to providing school bus transportation.
But that's not what the statute says, is it? The statute says that this section shall not be applicable to any employee who is employed by an employer licensed and regulated pursuant to 159A. So the employer, not the portion of the work that the employer has the employees do. So I guess my question is this: why aren't we just looking at the plain language of the statute and saying, hey, look, this is for the legislature to fix?
Because the plain language of the statute requires, our argument is it requires a look at whether or not the work is regulated pursuant to Chapter 100.
Well, then they could have just written the statute to say an employer licensed or regulated pursuant to Chapter 159A unless excluded under that chapter as charter services. That would have done it. They know how to read 159A as well as 151.
Well, this is in part why it does make sense to look at the FLSA upon which it is modeled, because they drafted it very similarly, using the same words by an employer, or in the case of 213B17, or any employee of a particular employer, knowing at the time that those exemptions had never been applied in that way and were not intended to be applied in that way.
So is there anything in our legislative history that suggests that they were really looking to the FSLA as the model?
For this particular exemption, I don't have any
No, anything has
legislative.
to do with the statute? I mean, is it in terms of the timing or anything else? I mean,
Yes,
is-
if you
any-
look at, this court has addressed that question, and it addressed it specifically in the Swift v. AutoZone case, in which this court found explicitly that the Massachusetts overtime law was modeled on the Fair Labor Standards Act. The Fair Labor Standards Act was enacted in the late 1940s. The Massachusetts overtime law was enacted in 1960.
Did you say it was Swift
Swift v. AutoZone, yes.
v. AutoZone?
Did you take a look at the Seventh Circuit case, the Chicago Transit Authority case, where the Seventh Circuit held that the ordinary meaning of to and from school means transporting students at the beginning of the day and the end of the day back and forth from home to school?
Well, I would point out that in that case, they were not looking at the to and from school language. They were looking in part at the definition of school operations, which is a different term. Moreover, they were, if you look into it, they were looking and discussing regulations which specifically use the term to and from home. And in various examples, federal regulations, federal law, and in fact, state law, if you look at Chapter 71, Section 7A, use the term to and from school and home, specifically using the word home, when they intend to limit the travel that they are discussing in that way. The fact that despite the various amendments to Section 11A of Chapter 159A, the legislature has never added the word home is quite significant when compared to this other legislative language. And also, in the last round of amendments, they added the last sentence, which makes specific reference to school buses under contract with a school being used to provide transportation to extracurricular activities.
The question I've got still goes back to, what are we going to do? We don't have the facts, right, to just, if we think that only part of that the charter activities are separate, say we agree with everything Justice Gordon did, but think that the charter stuff is a separate thing that needs to be calculated. We don't know the numbers, right? We have no idea what percentage of time they're doing for
Well, there's a
Justice Curran granted summary judgment on that issue, but we don't know the facts on that, do we?
Well, there are facts in the record. There is a dispute between the parties as to what particular percentage of work would be related to private entities. It's undisputed that all of the morning and afternoon work is not subject to the regulation. And we argue that the charters related to athletic events.
I understand the dispute.
So-
And I'm just trying to say we agree with you on that charter school activities, including the sports events, are excluded, but we don't think this applies to weddings and other things. We don't have the facts to determine what percentage actually happened, right?
Well, there's no particular finding as to, there's a discussion about a particular year, but the court did not make findings regarding all the years. I will say that,
How would we decide? We'd have to decide based on that if a certain percentage is covered, then we can decide this case?
well, at least 50% of the work is related to morning and afternoon school transportation. Beyond that, even though it's disputed, even if you went by the employer's numbers, which we think are high, their argument is that 43% of their work is related to private
But he's arguing-
charters, which would
he
mean
arg-
that 57% are related to school charters.
He's arguing that even if you win on all of this, if like 20% of this is somehow driven for weddings, that everything is excluded from the Fair Labor Standards Act. That
Yes, and we disagree with that interpretation.
Do you think that summary judgment should have been granted by Justice Curran. I understand you thought Justice Gordon was right. Do you think Justice Curran was right?
Yes. Summary judgment could have been, we could have desired a slightly more specific order, but we believe that summary judgment was appropriate under either standard. The record is clear, and there's no dispute that more than 20% of the work they do is not regulated. So under one theory,
But we need to adopt the Fair Labor Standard Act interpretation to.
you don't
say-
need to adopt their specific standard, but if you want to look solely at whether or not they perform a substantial amount, they perform more than 50%. That can't be disputed.
I think he's arguing the opposite. If they provide a certain, even a smaller percentage of exempt work, meaning wedding work, then all of their work is exempt.
Yes, well, I think that's two different, they are arguing that. I do not think that is what either of the Superior Court justices who dealt with that came to, so.
That was the difference between going to the Motor Carrier Act versus,
Well, the Motor Carrier Act exemption does require a look at the work, but because the language of that exemption was drafted more broadly here, there has been some court interpretation of the Motor Carrier Act exemption that all you do is you look at whether or not, and that's because those are the words that are used in the exemption, whether or not an employee is subject to the Secretary of Transportation's power to establish qualifications and maximum hours. And the courts have said, well, even where that power has never been used, and even where the employee may only step in, and this again, under the Motor Carrier Act, they're looking at whether or not people are, not whether their work is regulated, but they're looking at whether or not they get on to engage in interstate commerce. So in order for the Secretary of Transportation to have any jurisdiction over them, they have to engage in some amount of transportation. And they have said, well, some courts, there is a difference. They cite to some cases that have looked at a very small number saying, well, when you have engaged in interstate commerce, and even if not all of the employees in your business have, we'll find that they are subject to the possibility that they might engage in interstate commerce, and therefore there is jurisdiction there, and therefore they are exempt. And that is why I say that it is important that the language of the Motor Carrier Act exemption is drafted so differently than what we're looking at under Part 11. We're not looking at whether or not someone is subject to a certain amount of regulation.
All right, thank you.
Thank you.